Thank you very much, Rosabelle, and welcome everyone. It's very nice to have so many of you joining. We can imagine that you all have busy schedules. So my name is Wenehult. If we move to the next slide, you will not just see me on camera, but perhaps also on the picture here. And I'm a partner at Elmsted law firm. I have been with the firm for over 8 years by now, and I will be holding this seminar alongside my colleague, Knut Elmsted.
Hello everyone, my name is Knut Elmsted and I'm an associate at Elmsted law firm and has been so for almost 3 years.
And as mentioned, we're very happy to have this seminar with you today. We have some very significant changes regarding the employment protection in Sweden coming up. Some of these changes has already actually entered into force. The rest of them will do in just a matter of weeks. And employment protection and the Employment Protection Act, that's sort of a cornerstone in Swedish labor and employment law. It has been in place since the 70s. Many parties and politicians have tried to make changes of all kinds, and no one has never really succeeded to make any significant impact on this legislation until now. So we're quite excited now that it finally happens. And today's agenda is basically to walk you through these changes on a very high level basis. We'll not have time during 1 hour to go into too much details, I'm afraid. We will let you know when these changes enter or has entered into force, of course, and some practical measures on what we believe that HR departments or any employers managing staff in Sweden should do next or think about next. And as Rosabelle also mentioned, we will of course try to make room for questions along the way. So why not just jump right into, well, the core of employment protection in Sweden and talk about terminations of employment. Naturally, the Swedish Employment Protection Act is based on this essence that surely an employer cannot just terminate an employment for whatever reasons. There must be, as we say, objective grounds in place. And basically you can have two objective grounds for terminating an employment in Sweden. It's either personal reasons related to misconduct or poor performances, refusal of work, etc. The employee's failure, you could summarize it. Or the other ground is related to the changes on the business, redundancy, simply. Closing down a business, shortage of work, downsizing, all organizational changes falls in under this category. So this was just a little introduction to the essence of this law. And now we look at the practical changes of this concept. Moving on to the next slide, you will notice that these objective grounds will be replaced with objective reasons. And now this may sound like a very irrelevant change, but it will have some impact, especially when terminating employees for personal reasons that I just mentioned. When you have to terminate an employee in Sweden today, or according to the old rules in Sweden, for misconduct or poor performances, the employer must somehow try to evaluate or assess the future. Is there really no room left for improvement of this employee? No other measures to implement that could actually help the employee to improve his or her performances, change the misconduct, or whatever. We may talk about warnings, relocations, changed roles, etc. The employer sort of still has to make an assessment of the future, which is always very critical. And the court of law may consider other aspects as well relating to the employee's interest of keeping his or her job. It may be the age of the employee, that it comes with difficulties to find a new employment, etc. So there are, in summary, a whole lot of aspects to consider, and making an assessment of the future of someone's conduct or actions or performances is always very critical for an employer. Coming up, objective reasons. intends to make this assessment much more predictable. We will see if that's the case, but the answers of the changes is that, well, you're not really supposed longer to make an assessment of the future conduct of an employee. The focus should now be on the seriousness of the failure, the seriousness of the misconduct, and how much that has or may have damaged the business. So try to concentrate the assessment, try to concentrate the argumentation from the employer side to that particular question. They're still, of course, relevant, and all of that has been relevant before, obviously, but now it will be a whole lot more in focus. And also, an employer should obviously try to solve every staffing issue by other means than terminating the employment, trying to relocate the employee, for example, try to issue a warning letter, etc. But it's become more clarified now that one offer of relocation should be enough, unless there are very extraordinary circumstances involved. If you have tried to relocate an employee that cannot perform in the current role, etc., that's the only chance the employee will get from now on. So if it doesn't work in the current role, the employer will have a strong case for termination due to personal reasons. So that's the essence of the same. Subjective reasons will mean a lot more focus on the seriousness of the failure, the seriousness of the misconduct, other than perhaps thinking or assessing the future conduct of the employee. And a detail here worth mentioning before moving on to the next slide is that collective bargaining agreements are used to a large extent in Sweden. It will be possible, it is possible to elaborate on this concept, objective reasons, through collective agreements. That has already been done, actually, by unions and employers association on a central level. So it may be worth to be aware of for all of you that have businesses in Sweden that are bound by collective agreements, to be more acquainted with how those agreements elaborate on the concept. First, objective reasons. Other changes, and I will leave the personal reasons of termination and move on to the other basic ground, redundancy. In first out principle. And to give a little background, in Sweden, the employer enjoys considerable freedom to terminate employments for business-related reasons. In the end, it is the employer that decides the organization of a business entity, that decides the development and organizational structure of any kind. So redundancy as such is a strong argument to justify a termination. The employment protection in redundancy situation is basically linked to other positions within the unit. If an employee is subject to termination due to redundancy, the employer must look at two things. Number one, is there any vacant position within the business unit that we could relocate this employee to, that the employee is qualified for, and that the positions are in fact vacant. No need to establish new positions just per se. Those have to be vacant from the start. If there are no vacant positions, or at least no vacant positions that the employee is qualified for, then you do this last in, first out selection, meaning that the affected employee could claim a position held by a colleague with shorter seniority within the company. The employee in question must still have the qualifications for any role claim, obviously, where another employee may be terminated instead of the one who originally was affected by the redundancy. This follows a specific procedure. There are always unions consultations at hand if the employer is bound by collective agreement or if the employee is a union member. But now we have some changes coming up, and we can please move on and look at those on the next slide here. Small businesses in Sweden, that means we're talking about businesses with maximum 10 employees, had a favorable advantage with the old rules. It was possible to exempt or to protect 2 employees from this last in, first out selection. If you had two employees of sort of specific importance for the continuation of the business or so, you could protect them. Those roles could not be claimed, no matter of seniority. Now, this will be extended. This possible exemption will now involve maximum 3 employees, and it will apply regardless of the size of the employer. So basically all of you that have business in Sweden will be eligible to use this favorable rules of exemption in redundancy situations. It's obviously something to keep in mind and to think about who to protect in these situations. Normally it should be an employee with, well, particular importance for their continued work. It's also worth knowing that there is a limit for how many times you may use this exemption after one another. It comes with a 3 months protected period. If you have done it at some point during one reorganization, perhaps, you can't just simply reorganize the business each and every week and always use the exemption of 3 employees when others become redundant. So if you have done it one time, you have to wait 3 months, basically, until you can do it again. Also, this is a rule which are normally elaborated through collective agreements. It may look very different depending on which sector you belong to, but also worth mentioning, I believe. That's another favorable change from the employer side.
Yes, and let's move into the third favorable change for the employment side, namely what happens when an employment ends in case of dispute. Today, an employee who in the event of termination claims invalidity of the termination and reinstatement must remain in employment until the dispute is finally settled. That right is now disappearing, which means that there will be significantly more predictable costs for the employer, at least during a period of time, as the employee will no longer be employed during the process. If an employer has dismissed an employee, the employment will end at the end of the notice period, even if a dispute has arisen regarding the validity of the dismissal, and the employee shall not be able to obtain such an interim decision from a court that has been the case previously. However, it is still possible to claim invalidity, and if a court in its final decision declares that the termination was unlawful at the time, then must the employee obviously be compensated financially for the loss of income that she has had during the process. Employees will, in the event of disputes, no longer receive the compensation from the employer. Instead, will they receive compensation from the unemployment funds. There will be no waiting period for the employee, provided that the validity of termination is subject for a dispute. There is one exception from this rule, namely for local trade union representatives at the workplace. If a dispute arises about the validity of a termination of a local trade union representative at the workplace, the employment shall actually remain until the dispute has been finally settled, as the case is today, but only if it's of special importance for the trade union's activities at the workplace that the representative employment actually remains at the workplace. And it will not be possible to make any derogations in collective bargaining agreements. So this will apply on everyone, you could say. But the opportunity to be reinstated has had a general preventive effect, you could say, where employers have been quite reluctant in making employees terminated, for example, due to personal reasons, by knowing that the employment will remain until a court has finally decided upon it. So in order to compensate the employees for this change, the legislator has suggested that the punitive damages shall be increased according to what's on the slide, namely that summarily dismissal is currently roughly around 125,000 Swedish crowns, and that shall be increased to 190,000 Swedish crowns. And in case of termination, from current figures around 80,000 Swedish crowns to 135,000 Swedish crowns. And we can move to next slide. Perfect. And we will discuss priority list in case of reduced working hours. Because as Petro was talking about earlier, in a redundancy situation, the employer must first look into if it's possible to actually relocate an employee. At present, an employer can offer a relocation without applying the last in, first out principle by basically offering the employee a lower employment rate with a reduction in working hours already from the first day of relocation. If the employee has refused such an offer, the employer has or have had objective reasons to terminate the employment. And in case law has significant reductions in working hours been accepted. So this has been the market practice, at least to some extent, on different areas of the labor market. But the new proposal means that in case an employer during a reorganization offers one or several employees within the same department holding the same working tasks, if any of those are offered a new employment but with only reduced working hours and no change in working tasks, then must the employer give the employee with the longest seniority at the company also must be given the employment with the highest numbers of working rate and hours. So the employer must in those cases apply the priority rule, which means that the employee with the shortest period of employment time must be offered the least number of hours if the number of hours are reduced as a result of the reorganization. And by same working tasks, then it's meant basically the same task within the same business unit, where there are clear job descriptions. Guidance may obviously be obtained from there, but otherwise shall it be the same tasks. A good example is, for example, within a store where you might find that the majority of the employees, except for the managers maybe, holds the same tasks. So this rule applies, for example, in a store. But in order for the priority rule to actually apply, the offer must mean reduced employment rate with a reduction of hours. A relocation offer that, for example, involves additional matters such as new responsibilities, duties, or a new department, then the relocation offer is extended and the new rule no longer applies, so it's quite limited. If an employee would accept such a relocation offer after offer according to the new rules, he or she is then entitled to a transferring period from the old terms until the new terms commences, and the transferring period is applicable to the notice period that he or she would have had if they were terminated by the employer. We can move to next slide, please. And next slide, thanks. And we are going to talk about special fixed term employment, which is a new employment form which has been implemented by the legislator. And the purpose with this is to strengthen the employment protection for employees by making their employments earlier to become for indefinite term than it is today. Today, namely, a fixed term employment transfers to an indefinite employment first when employed for more than 2 years. With the new special fixed term employment, the employment shall turn into an indefinite term if the employee has been employed for more than 12 months during either a 5-year period or for more than 12 months during a period when the employee has had a fixed term employment, and that is either special fixed term employment, temporary substitute employment, or a seasonal work, and that the employment has followed on one another. And by that means that the employment has followed on the other if the employment starts 6 months from the end date of the previous employment. So there's no change for temporary substitute employments. Those still becomes indefinite term first after 2 years. So this change is only for special fixed term employments. We could move to next slide, please. Yes, and it's also the case that if a person has been employed for more than 9 months during the last 3-year period as a special fixed term employee, then the employee is entitled to a priority right to reemployment to a new special fixed term employment. And as usual, the condition is that the employee has the sufficient qualifications for the new employment. And also due to this, the provision changes also from when an employer must inform the employee that the employee will not be extended according to section 15, which must otherwise be left after 1 year and which must now be left after 9 months, corresponding to this new rule. And lastly, if an employee is employed occasionally as a special fixed term employment on a more day-to-day basis, the new rules will lead to the period between the different employments to be counted as one period if a person has had 3 or more employments during the same calendar month. The employment will then be considered to have been ongoing from the first employment date to the last employment date. And as you will see, it is possible to make derogations in collective bargaining agreements, while you must look especially into such if you are bound by any collective bargaining agreement.
Right, so now we've been talking about various topics for a while here, starting with employment protection in termination situations, new limitations regarding fixed term employments, etc. Now let's move on to a goal that has now been established. We haven't had really any similar expressed goal at the Swedish labor market before, but from now on, full-time shall be the main rule. So it is said, really. Surely it's still allowed to enter into part-time employment agreements for sure. But here's the thing, an employment agreement will be presumed to be on full-time unless it's explicitly clear that it's for part-time or not. And the employee can actually request to work full-time and expect to be given an answer and then motivation if the employer cannot accept such a request, really. So it's something that may need to be prepared of, that full-time should be the new normal in Sweden, Swedish labor market. There are a lot of sectors where part-time employments are very much dominating for whatever reasons, but now the aim or the goal should be on full-time employments. And a full-time employment in Sweden, we don't really have a fixed number of working hours per week. We have a working hours act that says 40 hours per week is maximum, but depending on which sector your business operates within, you may find the weekly numbers as 37.5 or 38 hours per week as a full-time employment. So that could be very much sector specific, I must say. And looking at the next slide, now we're going to change focus again to other changes that applies to agency workers. You may have consultants involved in your business in Sweden. You may have employees that operates at customer premises, etc. All of those are not necessarily considered agency workers in this context. That's the first question, I imagine. Who is an agency worker and who is not? The definition is basically an employee that is employed for the purpose of being hired out to customer companies to work under their control and management. And the key words are normally the control and management of the customer company. Perhaps you may have consultants working for other companies than their actual employer. It's questionable if the control and management of their working task lies within the customer company or their employer, in fact. So it may be a tricky assessment to be carried out on a case-by-case basis, but it may be something worth looking into now, no matter if your business have employees that are employed for the purpose of being hired out, or if you have consultants, independent contractors involved in any aspects. The customer company in this context that actually, well, brings on an agency worker, consultants, or whatever, previously only had the obligation to inform that individual about indefinite term employments at the customer companies. It was an informative requirement, and then the agency worker could apply for job openings at the customer company, just as anyone else could. There was no obligation to hire that particular agency worker or anything like that. Now, there is a much more formal obligation for the customer company here, worth emphasizing. that if an agency worker has been involved, engaged, and worked at the customer company for at least 24 months during a period of 36 months, so quite concentrated, that person must be offered an employment with the customer company. Surely, it's something that the agency worker can choose to reject, of course, and continue to work as agency worker for pretty much a long period of time. At least there is no absolute definition of how long. It's supposed to be a temporary thing, but we don't have a cap of number of years in Sweden for the moment. But if the agency worker accepts such an offer, then the employment will simply just transfer to the customer company. No real formality is required in regards to the previous employer of the agency worker. If the customer company now finds themselves in a situation where they really do not want to employ an agency worker, it is possible to instead pay a compensation to the agency worker of 2 monthly salaries instead of offering the employment in that case. That payment should then be made quite in conjunction with this 24 months limit. But that is possible anyway. So I guess to evaluate at least who may be an agency worker or not, that's something we haven't really had reasons to evaluate very much on in Sweden previously. But now this may be more of a key factor for your businesses. If you have agency workers engaged by your business, or if your own employees could be considered as agency workers as well. And this is surely something that may be derogated from in different collective bargaining agreements. I mean, surely we have staffing agencies in Sweden that belongs to the same employers association, and will surely find other solutions through collective bargaining agreements.
So yes, we have then informed about the different rules, and we now move forward to when the different rules begin to apply. The new rules entered into force this summer, but will be applied first from the 1st of October, so within a couple of weeks, as Petter said earlier. There are some specific rules, though, for general fixed-term employment and special fixed-term employments. First of all, for general fixed-term employment, which is entered before 1st of October, the previous regulation applies when an employment is transferred to an indefinite term employment. That means that the 2-year possibility is still possible if the commencement date is before 1st of October. So if you are about to employ an employee as a general fixed-term employment, then should you act quite fast. Also, if the company earlier has had an employee in a general fixed-term employment and after the 1st of October enters into a new special fixed-term agreement with the same employee, then will the period of time that the employee has been employed as a general fixed-term employee be taken into account, depending on when the general fixed-term employment were applicable. If it was from 1st of March this year, it shall be taken into account. So this means that in case the employee, for example, has been employed from 1st of April until last of June this year, and you want to re-employ the same employee from, let's say, 1st of November this year, the 3 months from April until last of June shall be taken into consideration when assessing when the employee will become an employment for indefinite term, that is after 12 months. So the possibility in my example would be that the special fixed term employment may only durate for 9 months. Moreover, it's important to bear in mind the 2 additional rules that applies for fixed term employments that I instructed about earlier, where the employer must give information 1 month prior to the end of the termination of the employment, but also the right that if a special fixed term employee has been employed for more than 9 months, then is also he and she entitled to a re-employment to a new specific fixed term employment. And those rules applies from 1st of October on general fixed term employment as well, but then also counting from 1st of October as a starting date. And also, in the event of dispute regarding a dismissal, older rules apply until 1st of October if the employer has sent a request to consult or notification regarding the intended dismissal before 1st of October, then will the older rules apply. And the same goes for in the event of dismissal due to redundancy, then will the previous priority rules that Petter described earlier, those will apply if the employer before the 1st of October has requested a consultation. So it will be important to have a checkup on the dates when sending, for example, a request for consultation or a notification regarding a intended dismissal. We could move to next slide, please. And the recommendations to HR that we have thought about are, to begin with, of course, look into if the company that you work with have a collective bargaining agreement. What do the new changes really mean? And have there been new collective agreements that maybe derogates from the law in accordance with what Petter and I have described? Also, review the documents and templates that you have so that they comply with the law. Here you may have, for example, internal routines for the procedures. For example, when unemployment is terminated, what rules apply to priority, relocation offer, etc. All such must be updated in accordance with the new rules. It is also important to review what applies to employees covered by the new rules on special fixed term employment that I have been describing. For example, be aware of their rights already from 9 months of employment and ensure that they are informed, for example, in accordance with the new rules. What you also have to look into is the last bit that we described regarding agency workers, that they are employed, and be aware of the obligation that this exists. The qualification period, however, will begin 1st of October. So the possibility to become an employee is first within 2 years' time. So it's obviously in the future, but can be important for business to know now already. And also, full-time is the norm unless otherwise stated. This shall always be clear in the employment agreements going forward. And we also recommend to at least set up a process for coordination and information sharing within the legal entity if you know that you have multiple offices within Sweden. Because if the possibility to exempt employees from the order of priority has been used in the recent month, you must be sure that it has not been used within the company going forward if you yourself want to make use of this.
Right, and I also mentioned in the beginning that some legal changes has already entered into force. We'll talk about them now in the end. Just as a heads up, these are new information's obligations. It's based on this EU directive regarding transparency of employment terms and conditions. So I would assume that most EU countries has fairly similar legislative updates regarding these changes. But from a Swedish perspective, this new requirement already entered into force as of 29 of June this year, after which date now they must be considered when entering into new employment agreements, and also your current templates of employment agreements, etc. May need an update to comply with these changes. Essentially, there's a whole lot more requirement on the employer side to provide the employee with information in writing about all conditions that are essential to the employment relationship. We talk about all kinds of employment benefits, like insurances or pensions. We may talk about working hours and working locations. Well, that must be very clear. If we have an agency worker in mind, it must be clear about which customer company that he or she will spend time working for, if that is possible to know, of course, at the time of entering into the employment agreement. And another detail worth noting is that also the rules and formalities to end an employment relationship should be provided to the employee already at the start of the employment. So it may not be the first thing that you think about, neither the employee or the employer, but that kind of information should be provided as well, how the formal procedure may look like upon a redundancy situation, etc. And another rule that we will give some attention to is a prohibition for an employee from having another employment during the employment with your business may be questioned from now on. Before, this has been something that one could perhaps agree upon with an employee, that if it is a full-time employment with your business, the employee should be prohibited from other engagements or other employments during the same period of time. Now, all within a reasonable range, of course. But now this has become more clear that unless it may be a competitor or it may harm the employer's business of any kind, you cannot prohibit an employee from having other employments. For a full-time employee, that would obviously be very difficult. So I guess the common example in this situation is perhaps a part-time employee that needs to find another part-time job within the same type of business and shouldn't be prevented from doing that. So yeah, I mean, to some extent, this is a legal change to be aware of, and also worth considering on to which extent you may permit outside activities for your current employees in Sweden. Now, we're not only talking about other employments, we may talk about other engagements, etc. So evaluate if your current wording in your employment contracts are updated to comply with these legal changes. I believe there is a question here as well. It's a good timing here to address. The legislation says to include information on training. We have no mandatory training. Do we need to include a reference in the contract? Yeah. Sorry, here are more questions coming up. Is it sufficient to have information available on HR website? First of all, it's very much correct that if there are mandatory trainings that the employer must provide to the employee, that is something that the employee should be informed of. Now, most employers in Sweden, I can hardly think about anyone has any mandatory trainings that they must provide to employees. So for 99% of employers in this country, this will be irrelevant information. You do not have to provide information due to this legal changes about all internal educations and educational programs that you may have. It's of course not wrong to do that on the internet or whatever. There's no legal obligations to have wording in the employment agreement about such internal education activities. So unless you have a really mandatory education or training that you must provide to all employees that you employ, you don't have to mention anything about this topic in the employment agreement. No. And I understand the one who asked the question that they have no mandatory training, so that's pretty much the answer. And it may be another question coming in. Let me see. Yes, of course, if the new information obligation applied to existing employees already in place, or just employees employed after 29th of June. It actually applies only to the ones that you hire after 29th of June. So you don't have to rewrite each and every employment agreement for your current employees. There's no need to that. It may be the situation that a current employee approach the employer and says, well, I want to have more information about my terms and conditions here. If it's on the employee's initiative, then you may have to provide that person with the same information that you will provide to your future employees after June 29. But you don't per se have to go back and rewrite or correct each and every employment agreement in the business for your current employees before June 29. No. And I see we have a question 3 as well. Is there a way to agree on exception to the length of fixed term employment, which are based on special programs related to education of employees within the company? Such programs may last for a longer period than 12 months, but to guarantee good terms and conditions, the person gets a Swedish employment contract for this period. I see. I mean, the essence, can you sort of agree about other lengths of these fixed term employments? I mean, the Employment Protection Act in Sweden is a mandatory law that you can't really derogate from unless it is made through collective bargaining agreement or, on the other side, to the benefit of the employee. So these timeframes for fixed term employments are indeed fixed, I would say, unless there is a collective bargaining agreement that says otherwise. An individual agreement with an employer cannot derogate from these length of fixed term employments. So I'm afraid you are a bit locked to this period of time in Sweden. Maybe a question for you, Knut, question number 4.
Yes, question number 4. Relocation means transfer employees to another department. We are not talking about relocating them to other legal entities inside or outside the country, correct? And that is completely correct. The relocation possibility that has now been limited is when you relocate an employee to reduce number of hours within the same department, the same working tasks at the same legal entity.
I see more questions on fixed term employment, so you may want to continue with this one. This is your area of expertise.
Another question, practically, do we have to offer fixed term employees permanent employment? To clarify, what do we have to do to offer permanent employees to fixed term workers? So once an employee has been employed within a special fixed term employment for more than 12 months, then is the employee transferred into an indefinite employment. So basically, you as an employer actually don't have to do anything, but it's of course recommended that you either engage on a new employment contract where it's clearly stated that the employment is for indefinite term, or that you, before this date, decides to terminate the employment, the special fixed term employment then. And the next question is a question about providing a brief distinction between special fixed term employment versus regular fixed term employment. And there are actually not a distinction, because previously fixed term employment in Sweden was called general fixed term employment, and you usually mention that as a fixed term employment, but this now only changes to a special fixed term employment with the limitation of 12 months. There are other types of fixed term employments, for example, as seasonal employment, as I said earlier, but also substitute employment, but that's separated from the special fixed term employment.
That's a good thing to bring up, because the concept of regular or general fixed term employments will no longer exist in Sweden. We will now only have special fixed term employments. And the essence, like you explained, is pretty much that the maximum period is 12 months and not longer as 24 previously. So another sort of change regarding the wording, like the objective grounds, objective reasons, and regular fixed term, special fixed term, could be seen as quite irrelevant as a starting point, but it has some impact for sure. And question number 7 is a very interesting one. How in detail does insurance and benefits need to be in the contracts? If the insurance or pension agreement change, does the company need to make updates to contracts? That's a very good one, and I will elaborate a little bit on this one. As a starting point, insurances and benefits, surely important terms and conditions of the employment that the employee should be informed about. What we normally see is that those type of benefits are laid down in a company policy or so of any kind, not always included in the employment agreement, because that could be quite extensive wording to include therein. There's nothing wrong with it, of course, but we normally see that those are laid down in a company policy and that the employment agreement simply refers to that policy. That is fine to do. also going forward. And if you then want to change those terms and conditions therein, details of any kind, I guess it's important to make the company policy clear that it may be a discretionary one, or that unilateral changes may occur. It may come down to an interpretation of whether you have agreed about a specific terms and conditions for pension with your employees, or if you simply have more like a company policy that the employer governs unilaterally and may change from time to time. But as far as the information, is fine to keep that type of information in a company policy. And I know insurance providers normally have quite extensive and good information of their insurance packages and so, and all necessary information that you could pretty much take or copy paste and lay down in a company policy. So that's what I would do. And I believe that question number 8 is pretty much on the same subject. If you do it on an intranet or HR web page, I think those internal HR web pages or company intranet and so are still something that could be very useful in this context. It is obviously important that the employees know where to look. It's preferable if the employment agreement can at least refer to the intranet in that case, or name of the policy or any kind. But yes, the essence is that you do not have to write all of this kind of information in your employment agreements going forward. You can still keep those at the intranet or company policies, but it's recommended to at least refer to those clearly. Let's see here. If we have any written notes of all these changes that we can send around to participants. I believe brief bullet points of all of these is something that we can surely provide. We need to ask your assistant Josabel to send them out, obviously, but we can surely provide the bullet points of the changes. Yes.
And we have a question number 10 regarding substitute employees. What about a person who is employed as a substitute for another employee on parental leave? Can that kind of employment, vicariat, be longer than 12 months? Yes, such employment can still be for 24 months, 2 years in time. So it's only special fixed-term employment that changes. Substitute employments remains to be engaged for 2 years' time.
Reading now question number 11.
Yeah.
Yeah. There's a good way to employ student employees who normally work on the side of completing their studies and may work only very few hours, month in some other way than in special fixed-term employment. Such student employees may wish to work for, well, like 2 years part-time when completing their studies, but often very limited number of hours, months. And that's an interesting one, how to manage that situation. I mean, the cap on 12 months for a special fixed-term employment will apply nevertheless, no matter if it is students working part-time or any other employee working full-time, really. Another way to perhaps deal with this kind of situation is to employ these student employees on an indefinite term, permanent employments, but just make it clear that they have a hourly wage and are paid when they are working, so that the number of working hours are not fixed for every week, unless you would prefer that, but that those could vary and they are paid only when worked. So that's another option to try to deal with this. And I would assume perhaps that they already have an hourly wage instead of a fixed monthly wage if they work only a few hours every month or every week, and in sometimes perhaps nothing at all for a very long period of time. So there will be ways to deal with that situation and not use a special fixed term employment if you do not think that is suitable. we'll see if there are any more questions coming in. Totally fine with us. We have saved time for that. No more question is what we are being told, and I could just please summarize the conclusions we believe of these changes. Yeah, we have one more. Let's do that first. Let me see now. If you could add into a student worker contract that the contract will automatically end if the student is no longer enrolled. Also a very interesting one. I guess the concept of student worker contract doesn't really exist in the Swedish law, but I understand what it is, what I think it is. I mean, something that a job that the student have, but only as long as being a student, obviously. So I guess if you would add something in the contract that says that it will automatically end when the student is no longer enrolled, it would be sort of a fixed term employment, but the ending date is not really decided upon in the end. I guess it will have to fit within this maximum period of time for special fixed term employment anyway. But yeah, I've had these kind of questions before, that the contract will end as a specific happening occurs or so, or if a condition is no longer fulfilled of any kind. I would say a general answer that it is questionable. It's something that we need to look into more in detail. It's not necessarily impossible, but I believe it is something that we must evaluate on. It depends on factors like, well, reasonableness in conjunction with such contracts. Then surely, as long as the employee and employer are in agreement and are fine with such a solution, there will surely not become any dispute of any kind anywhere. But then, just to give you a brief summary, if we would do a pitch elevator of these legal changes in Sweden, I would say that in the very essence, the employment protection in Sweden will to some extent be weaker. It's supposed to be a little bit easier for employers to argue that they have grounds, personal objective reasons to terminate employees for personal reasons, and there will be opportunities to protect more employees in redundancy situations. On the other hand, the use of fixed term employments and agency workers will be more limited going forward. So that's, I guess, what the employee side, the union side wants in return. If it's more easier to terminate people, then there shouldn't be such an obstacle to hire them on full time on the permanent or indefinite employments. So I guess that's the legal changes then in a nutshell, really, as far as Sweden and employment for the moment. I believe there may be one last question here, actually, before we hand over to Josebel. If a full-time employee wants to work part-time, must the company accommodate? That's a very interesting one. It's usually the other way around, but there could be situations where you are entitled to work part-time for a limited period of time. That is usually in conjunction with parental leave. So if the company must accommodate, potentially yes, but there must be certain reasons for that, typically parental leave, I would say. Depends on the situation, I would say.
I think there's one last question.
Yeah. Go ahead.
Yeah. How would two employers handle the situation where the same individual has a fixed term contract with both employers, which exceed the 12-month period? I don't know if you have any straight answer to that, Petter, but one employer needs to obviously take responsibility for their term, but it is possible to be indefinitely employed, that is permanent employment, by two different employers. That's perfectly fine, provided that it does not affect their ability to actually work by the both employers. I would say.
Yes, I agree. I'm not sure they need to handle it in any particular way other than
No.
for it basically mean that the same individual will have 2 indefinite employments after 12 months period of time for both employers. Yeah. Okay. Yoshibel, if you want to wrap this up, perhaps. It's very quiet. But from our part, we can surely say that we're very much appreciated that you have been joining us this afternoon. And as mentioned, feel free to reach out to us if there is anything else we can do to help you clarify and assist you with all of these changes coming up.